recording, and we're up to 15,000 people live watching the show as we're getting ready to kick off Lunch with Randy Wooden and Teddy Burriss, brought to you by Brookmeads Holdings. So cool. 1 second. Stops at 1 second. It's like we're never going to quite get there. So
where's the blast off?
Yeah, it's supposed to be a blast off. I'm like, I guess I can't go live on Facebook this morning. That's foobarred, and I got 1 second before we live. So you know what, Randy, let's just go with it, man. Let's just do what you and I do best. Does that work for you?
That works.
Cool. So
that works. Hey, everybody.
Hey, Inez says hello. Did you said hi to Inez lately, Randy?
It's been a week or 2 or 3, I think, but yeah.
Wave, dude, wave.
And hello, I'll wave with both hands. I got my baseball today, Teddy. It's playoff time.
Is that like a stress ball?
It's a baseball. It's a baseball base.
Did your football team do well this past weekend?
Sorry, you're breaking up here. I'm sorry, Teddy. I'm a Patriots fan, so we're entitled to a time off every couple decades or so.
You showed up on the field and took a time off for the whole game, huh?
Yeah, unfortunately.
I'm sorry, man. I have no horse in that race.
Yeah. Hey, let me start things, Teddy. I'll turn it over to you, and then you can introduce our guest today. How does that?
Good stuff, man.
Let's see, we're right on the dot. It's 12 o'clock on a Wednesday, and that means it's time for our lunch conversation with Randy Wooden and Teddy Burriss. It's a show that we started back in April when everybody got sent home, and we said, what the heck? What are we going to do? We're cooped up here. Why don't we get together, have a little fun, and try to inform folks and encourage folks that might be in a job hunt? So that's how it started. And then after a week or so, we started to bring on guests to talk about certain topics, all related. Special guests related to different topics in the the employment process. And so today is no exception. But again, from a means of introduction, Randy Wooden. I'm the director for Goodwill of Northwest North Carolina's Professional Center. We're based here in Winston. We help professionals. It's totally free. If you know somebody that's looking, or if you've got a company that's looking at some layoffs, we're happy to try to help those folks to land somewhere else. Again, just reach out. I'm on LinkedIn. Been doing this kind of work forever and ever and ever, it seems like, but enjoy it. I love it. And my cohort and partner in crime is Dr. Teddy Burriss.
Doctor, yeah.
The doctor.
There are 10,600,000 people with the word doctor in their profile on LinkedIn.
Really? And are you one of them?
No, I'm not.
No, you're not. No.
So those of you who know me, I'm a LinkedIn strategist and trainer. I own a company, co-own a company with my business partner, wife, Burriss Consulting, and we're all about teaching business professionals how to use LinkedIn as a business tool. And Randy and I have been friends for years. Man, it was back in 2000 you moved down here, right?
Yeah, it was. Back in 2000. It seems like yesterday, but yeah, it's been a long time ago.
Yeah. So, Randy, do you want to let our audience know about our great news about our sponsor and introduce our sponsor before I introduce our special guest?
I can introduce our sponsor and also remind people in the chat box over here, because I'm going to be the chat moderator today. It's here on my computer. If you would be so kind as to let us know where you're watching from, what city or what country. If you're from outside of the United States, we've had people from across the globe actually join us. So we're amazed and astounded. But anyway, that's been what we've seen. Yeah. So please chat in your questions as well for Natalie. She's our special guest today to talk about employment law. We'll get to that here in just a minute. But Brookmeads Holdings is our very first sponsor, and we're proud to have them and excited that they see value in our show and the topics that we cover. So we'll talk more about Brookmeads Holdings as the show goes on today. As again, they're our sponsor. Today is the very first show. So it started somewhere, Teddy. We don't know where it's going to go, but let's have some fun with it. Why don't you get started, introduce yourself, and then introduce Natalie.
Yeah. So Natalie Sanders is with, I got to say it right. I got Brookmeads in my mind here. Brooks Pierce, a law firm in Greensboro, I believe. And Natalie and I met years ago, and I invited her in to have a conversation again about employment law, maybe labor law, and how that and job search. And by the way, Natalie will reiterate this just as I will. She's not here to be our attorneys. She's not here to represent us. She's here to give us ideas and let us be aware of things that we need to be aware of. So, Natalie, would you introduce yourself a little further to the group, please?
I'd be happy to. Natalie Sanders, I'm an attorney with Burriss. I have been practicing labor and employment law for many years, since 1995. My experience has not just been in private practice, but I have worked in-house and I have worked in management roles. I've had my own company doing some consulting, and now am practicing law again with Burriss, where I was a partner years ago and came back. It's been about a year now. Timing's been very interesting with all that's been happening with COVID, has changed our workplaces a lot and kept me very busy. It's been exciting and challenging, but glad to be here today and be able to give some guidance to people on what some of the hot topics are in the employment search. I'm going to be talking to you both from the employer side considerations and employee side, prospective employees, but I'm not going to give anybody legal advice. So if you have a very specific situation and you type that into the chat and you want me to answer, I'm going to have to politely decline. I can't give legal advice, but I am happy to talk about what the status of the law is, what resources and things are out there, and give some general guidance.
Yeah, good stuff. So I can't ask you a question about how to deal with my wife/boss and the fact that she keeps harassing me when I'm working. I shouldn't ask that of you live.
I'm not going to be able to answer that one, Teddy.
Teddy, there's no hope for you, Teddy. It's just not in the cards, man. Just on the cards.
So good. So remember, hit Randy up with chats, and Randy will let us know that there's something. He'll do a thumbs up. Good, buddy.
Yeah. Hey, something, and Natalie, something we hadn't mentioned before we went live today is that if you have a thought, you want to say something, usually we just kind of raise our finger just real quick like that. Complete your thought. You don't have to stop, but that just kind of signals to the other two that, okay, I've got something to add. And I just wanted to add that we have people watching from outside of North Carolina. We've got them from Staten Island, New York. I think we saw some from, what was the other state? Pennsylvania. Of course, yeah. A lot from the Triad. We've got them Raleigh, Durham, Cary. We've also got a question or two that we'll get to later. So we're off and rolling. Let's get started.
Good stuff. So Natalie, this is one of the things I hear about all the time, that employers want to know what you were being paid at your last job. And there's so many variables with that people struggle with it. What is the legal perspective of the whole conversation about salary histories?
Sure. Well, first off, from the employer's perspective, a lot of employers are getting away from asking about it, especially asking that salary history question. And the reason is that there's been a really strong push, and you've probably seen some things out there about it, that asking those questions and then setting somebody's salary based on that information, we're actually perpetuating pay inequalities. And so if you were in a position where you weren't making the same, we'll just using the same women. So if the woman has a lower salary history and then starts a new position and they're asking about the salary history in order to be able to set that salary for that position, it's likely to perpetuate that pay inequality. So employers are moving away from it. Some are still asking. It's not something prohibited here in North Carolina, but there are a lot of states that are going ahead and prohibiting it. But we're in the Fourth Circuit, and the Fourth Circuit currently doesn't say that that is per se discriminatory or pay inequality. What employees need to be thinking about is what employers are asking instead. And instead of asking the pay history questions, what they're starting to do is, what is your desired salary, or what is your expectation for salary in this position? And employees need to do their research. You need to go ahead and look at the Bureau of Labor Statistics has really good information look at it in the region that you're in and for the type of position you're applying for. You can get a good sense of what the ranges are, and then be able to explain why you should be at the high end of that range. You know, based on your education, your experience, what places you in the higher end of that range, but have that knowledge and be prepared for the question.
That's a good point. And you just brought up a resource that I hadn't thought about before, besides Glassdoor and other sites for salary. And Barbara just said salary.com, but Bureau of Labor Statistics in your region. Great idea. That's good stuff. So here's another one. Let's talk about the other big one. And that is when you're applying for a job and we have criminal records, whatever they are. We have, sometimes I refer to it as, mistaken baggage, that we made a mistake.
Right.
What?
That's another hot topic where you're seeing a lot of legislation actually out there. We refer to it as ban the box or fair chance laws. And here in North Carolina, Governor Cooper just in August issued an executive order so that basically for any state employment, they're not going to that criminal history or ask those questions until at least the first round of interviews have been completed. And some states are saying you shouldn't be asking it until after you've made a conditional job offer. So employers are starting to steer away from that. From the employee perspective, the law on it really comes out of Title VII and the potential for discrimination and discriminatory impact. And what the Equal Employment Opportunity Commission, you can Google, just go guidance from EEOC on criminal backgrounds, and you'll get exactly what they're telling employers they shouldn't do, that kind of thing. But the point there is that they're saying, is it relevant to a particular job? And if so, you still have to evaluate what is the nature of the criminal conviction, how much time has passed, and then how does it relate to the particular job? So if you're the employee, you need to be prepared to be able to talk about this comfortably and just talk about it matter-of-factly and what has changed and why it's not relevant to the job you're applying for.
Yeah. Good point. Yeah. I remember years ago, I was in Leesburg, Florida, hiring 15 landscapers. And as they walked into the where my truck was, I was sitting out in the middle of the field. The very first question my manager told me is, ask them if they have a criminal record. He said, and he said, don't pay attention to the answer, pay attention to how they answer. Today, it's a little bit, it's not the right way to do it. I'm with you. Yeah. So, Randy, thought?
Well, to kind of interject, before COVID, essentially, if you could fog a mirror, you could find a job. There were more jobs available than there were active job seekers, essentially. So if you wanted to work, you could physically do the work, and chances are you could find a job. But since COVID, the dynamic has changed. Now, companies are still, to include Goodwill, we have struggled to find workers to work in on the retail side, maybe because they didn't want to interact with the public. They could collect more on unemployment. It could be a whole host of reasons. So there are still pockets where it's hard to find work if you're in hospitality or you're whatever. I guess the whole thought here is, where is the bar these days? Companies, to include Goodwill, we've looked at saying, do we need to reevaluate the emphasis that we put on, let's say, drug or criminal history, in effect, to lower the threshold or lower the bar to say, okay, we'll look at this on a case-by-case basis versus just saying, no, you're not welcome. Do you see things changing as the economy, the job market is tighter? Do you see companies just walking away from this and saying, hey, we're not going to get involved because we can pick from, let's say, people with less of the baggage that Teddy talked about? Are you seeing that at all?
So the employers are trying to focus and avoid having any per se rules to criminal backgrounds or other types of things, drug screens and things, and focus on who's the best qualified candidate And in situations where there are lots of applicants, they can be very picky, and it's pretty easy to find really high quality there. But like you said, I have actually heard a lot of situations where there's a lack of employees available.
Yeah.
Yeah. So I think these things are still very relevant.
I know back years ago, you could essentially find an MBA to bag groceries. I mean, back when the economy was real bad, I mean, you need to eat. So things change, and it is cyclical. So good information. Teddy, I know there's another topic that's big, and that's social media. Right?
No,
That's
social media is not a problem. Nobody makes mistakes on social media. No,
if they listen to Teddy, they don't. Teddy will guide you and tell you what you need to do and not do. But for those of you who may have stepped on the other side of the line a little bit, I think you need to be paying attention.
Yeah.
Social media, that's one that the employers are looking at. But it's gotten, it used to be when social media was kind of new, employers were like, wow, here's this resource. And then they would not hire people based on what they saw on their social media, and people have to be real careful. Well, you still do to some degree, but employers are getting more sensitive to what the downfalls of that are. So for just a couple examples, a lot of states, including North Carolina, have laws about lawful use of lawful products, meaning an employer can't discriminate against you because you lawfully use a product outside of the workplace. And in North Carolina, tobacco state, that's where that law really came from, was if I'm a smoker, an employer couldn't really discriminate against me because I'm a smoker, right? That's a lawful use of a lawful product. They could say I couldn't use it in their workplace, but they couldn't find that on social media. So that's one of the things that's starting to come into play, is that people are saying, well, it's a lawful product, I'm lawful age, and they're discriminating against me because I'm using it. So that's one of the laws that employee sides are getting creative on with that social media background check sort of thing. Other things they're doing is saying, like, concerted activity and trying to fit things under the National Labor Relations Act. If you're out there talking about your employer and your work conditions and whether you're getting paid enough, that stuff might be some sort of protected activity. And of course, the other thing that the employers are often concerned about is, are they going to find out information they don't want to know in order to not be discriminatory? So might they find out about somebody's disability or religion or any protected characteristic that they really don't want coming into their decision-making process, that they could be accused of discrimination in the hiring. Yeah. So it's not as big a trend. And now there are actually organizations or companies out there that will run social media background checks, but they're covered by the Fair Credit Reporting Act, like any other background check.
Yeah. Interesting. Teddy, if you're okay with it, let's tackle a couple of questions we had. And we had one that came in regarding disability, and it's how to answer a question when they ask about your disability. If you need let's say, a reasonable accommodation, at what point in the interview process should you divulge that request? How would you handle that?
Sure. So there are a couple different things in that application and hiring process. You can ask for a reasonable accommodation to go through that process as well. So it may be you are hearing impaired, and in order to do your interview, you need to make sure that you have visuals, so you can't do a phone interview or something. There are a lot of different that could come up during the actual application interview process where you might need an accommodation. And then the flip side of that is, do you need an accommodation to perform the job? And that focus is very much on the essential functions of a job. So job descriptions are really becoming more and more important from that standpoint. So an employer who's going to engage in a hiring process should have a really clear idea and laid out job description, what they're looking for, what they really expect this person to do. And then from the employee side, can you do those things that are required? And people need to, both the employers and employees need to think about that a little bit creatively. So let's say I'm applying for a job in a warehouse where 50-pound boxes need to get moved from the intake dock to a storage area. what is the essential function of the job there? Is it that I can lift 50 pounds? No, it's actually that move those boxes from one location to another. So is there something that I can use to accomplish that, even if I can't lift 50 pounds? So we really need to think about that as what is the true essential function of the job.
Yeah, I get it.
Another question deals with, as a candidate, if you're asked a question that you believe to be illegal, what is your out there? How do you respond other than to say, you can't ask that? Do you have any recommendations if somebody thinks they're hit with an illegal question?
Well, first, one of the things I say is that interview process and that application process is also part of you deciding, is this who you want? And so do you want to work for someone who's not sophisticated enough to understand they shouldn't be asking those questions? Yeah, probably not. But you need a job. And so how do you address that politely? So if someone asks you, do you have a disability or do you have any health conditions that'll prevent you from doing this job? Try to find a polite answer. I'd prefer not to talk about my health at this stage in the process. I'd rather us focus on what the essential functions of the job are, and whether I can perform those or not. I think I'm qualified, here's how. But if you have an obvious disability, so for example, you are missing an arm, it's an obvious disability in a sense, it is appropriate for them to ask, how would you accomplish this task? How will you do this job? Without actually talking in depth about the disability, but focusing on the essential function of the job. So what they're supposed to be getting at in their questions and things is, can this person perform the essential functions of the job with or without a reasonable accommodation?
Yeah. Randy, before you go to the next question, years ago, Natalie, and I hope I didn't mislead this lady inappropriately, but she asked me about going out of state for an interview, and she said, hey, I just found out I'm pregnant. Should I tell my interviewer? And I said, no, it's none of his business. Yeah.
That's true, irrelevant to that decision-making process.
Yeah.
There are going to be situations where if you're being hired to do something and it's an immediate project and it's a particular time frame, and you're not going to be available to do that job, that's a different situation. Especially in a higher situation with pregnancy, we typically think of the Family and Medical Leave Act as providing our job protection for the leave associated with the birth of a child. But to be eligible for that, number one, it has to be a large enough employer, but also you have to have been there for a certain time to have earned that job protected leave.
Okay.
So, you may want to be off about it at that stage to know that you're not going to get into a job and then lose that job if that is a time sensitive situation.
Good point. Good
but
point.
Pregnancy discrimination is prohibited.
Yeah. Cool. I don't have to worry about that anymore. Inez popped down a question to me, Randy, and I'll bring that up. And that is, what if you have a disability where you do not need an accommodation, such as non-insulin diabetic? If you do not disclose, will this get you in trouble in the future?
No, you don't have to disclose all of your health conditions to somebody.
Yeah.
Now, I say that it obviously depends on the position. There are going to be some positions in some contexts where health information is relevant to performing the job. Those things do exist. Yeah. But in the typical situation, there shouldn't be any need for you to reveal medical conditions that don't require any accommodation in the workplace.
Yeah, good point. Good point. Good stuff. Back to the social media, Natalie. I don't know if this is is there a law around this or not, but I do remember some government organizations around the triad east of Winston-Salem, that they required you when you were applying for a job to log into your social media and turn the laptop around and hand it to the interviewer. Is that still legal?
I'd be surprised if that's taking place anymore. There are a lot of downside to asking people to give you passwords, because that used to be something that you would have employers saying, give me your login and password, I want to go in and see. There are some states that are implementing different laws to provide very specific protections, but that show me everything situation right now,
Yeah,
there are of legal pitfalls with that.
yeah, it was I'll have to go back and see if that government organization is still doing that before I can speak about them. So I don't disrespect them unless
I'd heard that too. Other companies around the country, I'd heard that from years ago.
Yeah.
Mm-hmm.
So yeah, we've had other.
It would be very common until there in some cases where attorneys started using, like I said, all these other types of laws to bring claims.
Yeah. Randy, do you have another one?
Not so much. As we get a couple other questions, but they sort of overlap a bit. And I know, Natalie, you had a number of topics you'd like to cover. So let's get to that.
This is great.
And we'll take a pause here in a few minutes and mention our sponsor at the bottom of the hour. But Teddy, I know you've got some other topics you'd like to cover.
Yeah, well, and by the way, it's close enough to the half hour because I don't want to interrupt Natalie when she gets going. I'll just go ahead and do the half hour statement. Yep. Hey, this is Lunch with Randy Wooden and Teddy Burriss. I'm Teddy, and this is my buddy Randy. Our special guest today is Natalie Sanders. This lunch event is brought to you in part by Brookmead Holdings. Brookmead's been around since 1993. They've helped thousands of individuals in lots of major industries across all fields of work, and lots of experience and, at different levels of responsibility. They do work. They do customized job search coaching for individuals and through professional development and training. They're a great organization in the Winston-Salem Triad area. And so if you're looking for career management support for yourself or for your team or for people in outplacement, reach out to Brookmead Holdings and get in a conversation with them. Their number is 336-814-8910. Did I do that right, Randy?
Call before midnight tonight. Once again, that number is 336-814-8910.
You didn't tell me before midnight tonight, dude. Golly.
I'll tell you what, a lot of folks that are watching are looking for work.
Yeah.
And other ones are just curious because they want to understand the law and just kind of get the latest and greatest on a lot of different topics. So if you are in that job search mode, obviously Teddy and I can help, but there's only so much we do on our end. And if you really need that higher level of coaching, then I think Brookmead Holdings is a place that you need to at least investigate and have that discussion and see what they can do to help you along. So yeah, a lot of other topics, Teddy. We could talk for hours here. So let's move on to our next.
Can I hit up Suzanne's question first before we go to accommodations, which I think
all right.
Suzanne asked this, Natalie, says, if you have signed a non-disclosure agreement when you leave a job, does it have an expiration?
So a couple things. Non-disclosure is a little bit different than a non-compete agreement.
Yeah.
And all of these different things are in the category of restrictive covenants. And the law in most states is to disfavor all of those things. And these things are even getting attention at the federal level. Before COVID got involved, there were some discussions that we might see some legislation at the federal level regulating what these kinds of agreements and things can look like. How much can somebody limit your ability to go to work for a competitor?
Yeah.
So the non-compete piece of it is extremely disfavored in most states. Some states actually prohibit it. In North Carolina, we have very specific rules about what would be enforceable. And basically they have to be reasonable as to time, geography, what it is they're limiting, those types of things. with respect to something like a non-disclosure. So we have laws in North Carolina and across the country that do protect a company's trade secrets and their legitimate confidential information. Some states pull on a duty of loyalty that employees have, whether they sign some sort of non-disclosure or not. Typically, a pure non-disclosure agreement is part of the evidence. It's a trade secret confidential piece of information that the company is diligently protect and try to protect that. At what point must it stop? At what point can you disclose someone's secrets in their company? At the point that they are otherwise public. So it doesn't mean that just because I have confidential information, like a non-compete, that's going to end after a year and then I can just use that company's trade secrets, the things that give them their competitive advantage. Think about it like the formula for Coca-Cola. If you've worked for Coca-Cola and you've been away for a year, it doesn't mean you can now share that trade secret, right?
Yeah.
Different levels of what's trade secret,
Natalie,
what's confidential.
now you tell me, Natalie. Now you tell me.
I've been telling the secret to the Coke formula. Oh no, Randy.
Yeah.
But yeah, you get the idea. It's different when you're talking about don't compete, don't work for a competitor versus don't use my trade secret and confidential information. They really can keep you from doing that for a whole lot longer.
Years ago, go ahead, Randy.
Well, I was going to say, we got a question from Dean. He said, now that a lot of us are working remotely, can an employer ask where you live and then pay you less due to that fact? I think a good example is New York City. And if the company says, okay, we can work remotely, and so I live in Idaho and the cost of living is compared to that, should I be paid differently for the same work that I would have been performing had I had to live and work in an office building in New York City? What's the law say about that kind of arrangement at this point?
Yeah, we're in a whole new world with this remote working, aren't we?
Yeah, we are.
And there are a lot of these types of issues coming up. Each state oftentimes has wage laws. Localities, I mean, you mentioned New York can have different wage laws in setting minimum wage, setting how tip systems work, setting when you have to get paid, and then you mentioned the cost of living. So what is the right place? Well, typically you're paid based on the laws on where you're working, where you're performing your work, where you're hired. But in this situation now, you're working from home. So your home state becomes relevant to an employer to make sure that they're complying with that state's laws. It gets pretty complicated. And it's new because we don't have a lot of situations like this. But yeah, if you would have otherwise been in the city of New York, living and working, and now you can work from Idaho where the cost of living is very different, an employer taking that into consideration, wanting to make differences in how they're paying people, that is not a discriminatory reason for paying people differently. When an employer can justify it very clearly and it's not based on someone's protected characteristic, it doesn't rise to the level of discrimination. Just, of course, they have to comply with the various laws.
Yeah.
Good.
Real good. So let's talk about accommodations for a little bit, and maybe in the context of around COVID, because this is a big issue. I mean, you know, we're hearing about teachers who are quitting their jobs because they're scared, because they don't want to be in that situation. So where does the law lead us in the context of accommodations around COVID, Natalie?
Sure. Again, there are no clear answers. It's a complicated mess. But first off, the normal accommodation law applies. That's the Americans with Disabilities Act. And do you have something that rises to the level of a disability? Most employers aren't going to start by questioning that. Most of the time, they're going to kind of skip over that and say that's a legal argument I can make later. And let's talk about whether there's an accommodation that you do need to help you do the job. In our COVID context, what we're getting a lot of is, I can't wear a mask. Okay, well, what is the reason for that? And then can we reasonably accommodate it and keep everyone safe in the workplace? Now, reasonable accommodation has another element is, can you provide a reasonable accommodation that allows the person to perform the essential functions of the job without an undue burden? And there's also the element of safely.
Yeah.
So can they safely perform it? And is there a safety issue with respect to the other people in the work environment? The thing that both employers and employees need to recognize when they're going through an accommodation process is what the law requires. And that is what I just said, an accommodation process, an interactive process. So you can't go to an employer and say, I need this accommodation. You can go to them and say, I need an accommodation. And then it is the employer and employee in consultation with any sort of healthcare professionals, what is a reasonable accommodation? So an employer isn't required to grant you whatever you ask, not required to grant you your ideal accommodation. They're only required to grant you an accommodation that is reasonable, it's not imposing an undue burden, and it allows you to perform the essential functions. So what you think your ideal is may not be what the employer is necessarily willing to offer, and they only have to offer and make available what will allow you to perform the essential functions, as long as they've gone through that interactive process.
I get it. And one of the reasons, I guess, why laws are written the way they're written, so we don't all try to interpret them so many different ways. A reasonable accommodation allows you to do the job without undue burden and safely. Did I get it right? Yeah.
Exactly.
Yeah.
In a nutshell, that's it.
Teddy, didn't you go to law school in addition to med school? I thought you were both law school and med school.
Harvard told me I'm not allowed to talk about that, dude.
Okay. We'll take that offline then. You know, I tell you, there is a lot, this whole COVID thing, and it's such a fluid situation. I know and Goodwill is just one example. We, as the CDC hands down additional dictates, we've had to modify our policies and procedures almost on a daily basis throughout this whole thing. And it's really, I use the term drawing up a play in the dirt, but it really kind of is. It's unprecedented. And I'd like to think that both companies and workers will be a bit more lenient and patient because we're in uncharted areas and we're trying to feel our way through this thing. And so it's sort of like being in traffic, just give a little more space and just kind of chill just a little bit. I'd like to think that employers really are trying to do the right thing because they want to retain good workers, and workers want to do the right thing, but they have safety issues and fears and concerns. And so not that there are competing interests or combating interests, but I think we can all kind of work together. But understanding the law, and those are the barriers that we don't go outside. But within that law, I think there's some latitude, and there's going to be more changes, right? I mean, we're not done with this COVID stuff.
Yep. The guy
I think
said
that's
to me,
right.
go ahead, Ellie.
And just, you mentioned the safety concern. That's a little different than the accommodation thing, because the accommodation relates to, I have an underlying health condition and I need some sort of accommodation, whether it doesn't allow me to wear a mask or it places me at higher risk, whatever those things are. But the issue of, I'm afraid to come into work because I'm afraid of getting COVID, that generalized fear isn't really protected under the law, okay? But if an employee has an actual concern about the safety in their workplace, they can go through OSHA, and they also have some protections under the National Labor Relations Act if they are engaged in concerted activity to improve those. But where it comes out, though, is what is your concern? The employer is going to be asking for your concern. Why are you afraid of coming to work here? What is it and what can we do? And if you can't identify anything that they're not doing, that they're not providing to you, you're just scared. Well, number one, it's okay to be scared. And it's okay to make that decision that it's not right for you to go to work. But it's also okay for the employer to say, I have followed all of the CDC guidelines to make a safe and work environment, and people are going to work every single day and not getting COVID. I expect you to come to work. So both things are okay, but employees need to understand that just, I'm fearful, isn't going to give you job protection.
Yeah.
I read, I'm active in our local SHRM organization, and I don't profess to be an attorney. So anyway, but I've read some columns that have been put out around COVID, and folks with disabilities where a company might say, rather than me having to put forth reasonable accommodations at the workplace, why don't you just work from home? Or some people just say, hey, you know what? I'd rather work from home anyway. You know, all I can do is go into work and I have a computer in it. Why can't I just do it from home?
Mm-hmm.
And so you get into the legal, is an employer obligated, or is it within the law to say, okay, fine, go work from home? Yeah. Or again, so many things, and we're not going to get into the mud with all that, but just know that if you're watching, that this is an evolving topic. And as we learn more, and as hopefully we know more, we do better. But we do have a question that came in. And this is one that came from Stephanie. She said, can an employer let you go if you can no longer perform essential duties due to a disability that formed after you got the job? So you got the job, you're fine, you're doing your work, you acquire a disability, and now what happens next?
Yeah. So if they're truly essential functions of the job and you can't perform them, there's no law that provides you that protection. Okay, you've got options if the disability developed because it happened at work. Of course, you've got workers' comp claim potentially.
Right.
If a leave of absence would allow you to a place where you can again perform the essential functions of the job, it's possible that discussing a leave of absence could be a reasonable accommodation. Not always in every circumstance, but it's possible. So discussing what might allow you to be able to perform those essential functions, but simply, in an at-will state in a non-union setting, if you no longer are able to perform the essential functions of the job, even if it's because of a health condition, doesn't mean that you have job protection.
Yeah. I get it. And a big phrase there, at will environment,
Let me ask you, can I jump in? When you say at will, because I get asked this a lot, what's the definition of that from an employer and an employee standpoint?
Yeah, employment at will means that the employer and the employee both have the right to terminate the employment relationship at any time for any reason without any notice. The only exception is they can't do it for an illegal reason. And that's where you start getting into the discrimination laws and things. Mm-hmm.
But still, the 2-week notice is a standard type thing. Even though
notice in an at-will employment situation is a courtesy.
Right. There you go.
It is not required.
Okay.
However, a lot of employers like to provide an incentive for someone to provide that notice. A lot of times when employers are talking to me about it, I say, well, what's your paid time off policy? Maybe you could say, if you give us 2 weeks notice, we'll pay out whatever accrued but unused paid time off you have. But if you don't give us that notice, you lose it. So they try to create some incentives to get the notice, but it's not required if it's true of that will.
Got it. Thank you.
I've tried to quit my job, Randy, and she keeps threatening me that she'll lock the front door.
Change the lock on it.
Let's do one more question, Natalie. I think we have time for one more question. Dean asked, can an employer fire you because you are, well, we may have already touched about this. You did. If you're worried about safety,
Yeah.
then you know that's your problem. As long, if I heard you right, Natalie, as long as the employer did all the things they could reasonably do to be able to protect you from safety and COVID, as long as they're following the letter of the law, CDC, et cetera, and all the safety rules by the OSHA, et cetera. If I'm worried about the job, then that's my bad. I've got to be willing to accept it.
Yeah, the only little nuance there would be if you raise a concern and you do it in good faith, you have some protections with respect to you can't be retaliated against and terminated. Yeah. So if I raise a legitimate concern and you address it and we talk about it, oh, okay, and I continue to work and then fired because somebody was mad that I was raising concerns that turned out not to be legitimate. If I, in good faith, brought those concerns, I might have protection under OSHA. I might have protection under the National Labor Relations Act if I was working on behalf of other employees to better our work environment, or if I was working in concert with other employees to do that.
Got it.
So there may be some protections there on the retaliation side.
We could go on forever. Let's, if you can, Natalie, bundle this. Take all the labor laws that you know about and bundle it up in a 30-second statement. No, just big picture. What in the conversations about the laws around salary and criminal records, background checks, social media, accommodations, in general, what do you recommend to a job seeker? What is the most important thing you can recommend to them?
So to a job seeker, I would say, do your homework to understand what the essential functions of the job you're applying for are, what you should be able to justify for a salary, and what are the things that are out there that you're a little uncomfortable about. Did you have something out there on your social media in the past? Did you have a criminal record? And be prepared to comfortably discuss those, because they shouldn't necessarily prevent you from continuing down that process of applying.
Yeah. I'm with you. I wrote down the phrase, be informed. Mm-hmm. I think that's probably the best thing I can think of in this whole context. And that is, and be informed doesn't mean be listening to Facebook and what your Aunt Myrtle said, what Randy's cousin Louie said, that's
I got a lot of cousins too, a lot of cousins.
Yeah, it's be informed through legitimate places that you're supposed to trust and respect. So good stuff. Randy, what are you thinking, man? What's in your mind?
Normally, I have a story to tell, and so does Teddy. But that we are in the political season, and I guess it's always the political season anymore. Yeah. So, in the spirit of the political season, I will yield back the balance of my time to Natalie and ask this question. And this is a question we didn't get to. Actually, two. One was, why did you get involved with it? What got you on this whole path? I never did ask you that. And secondly, politics, religion in the workplace, especially politics at this moment, is obviously, front and center and right in front of your nose. Any kind of laws pertaining to any kind of guidelines you can give workers and employers as it relates specifically to politics, but also religion as well. But first, why the law? What got you started with that?
First, why do I love the practice of employment law and helping especially employers get through these tough things? Mm-hmm. Because I think the employment relationship is so personal. If you're not going to do criminal law and you're not going to do family law, the next personal is really employment law. It is an ongoing relationship, and it has such different perspectives from where the employees come at it and where the employers come at it, and helping get to that middle ground where, and I love the fact that I'm very blessed to work with employers who really want to do the right things for employees. That has been a huge blessing in my life. And so I enjoy it. I enjoy walking through those difficult things, thinking creatively from business standpoint and the law to get to the right place. Now, with respect to the politics in the workplace.
You betcha. Politics
so-
in the workplace and
And
social.
I know we're running kind of short on time, so I'll try to be really short. But the one thing I would say to employees is, we have freedom of speech in the US, but when you work for a private employer, your freedom of speech doesn't necessarily go into that workplace. So a private employer can very much limit what you're discussing with respect to politics, what you're discussing with respect to hot topic issues. And in that regard, just keep in mind, you don't necessarily have the same freedom of speech right in your private employment. That said, employers will do their best to make sure they're being consistent.
Yeah.
And so they will, if they're going to say, we're not going to talk about politics in the workplace, then that's typically both sides. Or we're not going to talk about Black Lives Matter in the workplace. That's typically going to be both sides of that. Now, an employer, a private employer, can take a stand on something. So they can take a stand on a social justice issue. They can take a stand on something and say, this is what we believe, and this is what we're going to allow. But those discrimination rules are out there, and they're going to catch employers a lot of times. But it's not your freedom of speech that's at play and protected when you're talking about inside your private employer workplace.
What about outside of the workplace on social media, for example?
Mm-hmm.
Yeah.
So employers are going to tell you that what you do, depending on your position, can very much reflect on that employer. So if you are in a position where your actions and your words could be implied to communicate a statement about that employer, you're going to have a little different standard, right? Otherwise, a lot of employers will have social media policies, they'll have communication policies, and most likely what they'll say is, if you are on social media and you are talking about politics, make it very clear that this is your personal opinion and it doesn't reflect the opinions or position of your employer. And there'll be a lot of recommendations that you kind of put that disclaimer if you're going to get involved in those sort of things out there.
Yeah.
Real good.
Yeah, I remember years past, I worked for organizations that had, when I started using social media, their HR/legal counsel said I had to put a disclaimer that everything I say on social media is Teddy Burriss and does not represent my employers or my clients in any way.
Exactly.
Yeah, I still see that out there every now and then.
Very common.
Yeah. So
Thanks,
good
Natalie.
stuff. Good stuff. So it's 12:53. You got 7 minutes to wrap this up. Randy, who's our special guest next week, man? Do you have that? I can't remember.
I have it, and this is going to be a really cool set. Of course, they're all cool.
Everything is cool with us.
Everything is cool. But here's the deal. Noel DeBona is going to come in.
Yes.
Noel is a management consultant, but this is where it's going to get kind of fun. I'm going to read it so I don't get it wrong. Right. But it says he's going to decode. The topic is decoding your behaviors to improve interviewing and your relationships with coworkers. That's interesting in and of itself. But just so you know, Teddy and I each has taken the assessment. And
did I pass it?
And next week, Noel is going to do the big reveal about who we are and tell us how to play better together. How to work.
Finally, somebody's going to help us with that.
Exactly. And that'll be in the latter half of the show. So you want to make sure you stick around for the entire show next week and learn how we get to play better with each other. And I guess where we need to be aware of our strengths and areas of improvement. So that'll be next week, next Wednesday at noon. So yeah, Teddy, let's turn it back to you.
Yeah.
Take us home.
Natalie, I really, really appreciate you showing up and sharing and making us think and helping me reiterate to myself and share with everyone else. And that is, you need to be informed and informed again, satire aside, Informed is not through Facebook and social media. Informed is through people who are entrusted to give us logical, sane, knowledgeable advice. And it might start with your Bureau of Labor Statistics. It might start with, government websites, labor law website. It might start with a phone call to someone like Natalie and her law firm and say, I have a serious question. I need serious legal advice. I learned a long time ago, when it comes to stuff like laws, I often joke about Randy and I, we're lawyers and doctors, all that kind of stuff. But when it comes to serious things, I get on the phone to a lawyer and I say, dude, or whoever, I need help. And because the worst thing I can do is pretend I know the answers when I don't know the answers. So be informed and look for good guidance. So, again, thank you to Brookmead Holdings for being our sponsor. Great organization in the Triad area, all about professional development and outplacement support for business professionals. We're grateful that they've joined our team. Randy, anything else, buddy?
Just real quick, there's a topic we didn't cover. I know we've got just a couple minutes left, and that's age discrimination. Is there can you give a 30 or 60-second quick hit on that? If somebody feels like that's the reason that they either weren't hired or that they were dismissed, what's the real world like in terms of what they can do about it, if anything?
So age discrimination happens, of course. There are some states that have different laws, but generally the federal law says if you are 40 years and older, you are protected with respect to age discrimination. Oftentimes, if you feel that way, a feeling doesn't really get you a legal claim. There needs to be some sort of direct evidence where you can say so-and-so made these comments about me as the old geezer, needing fresh blood, all those sort of things. If that kind of stuff is happening, you may have a claim. The other thing is comparing to others. Is there someone who is similarly situated, who is younger, who's being treated better than you? Having those comparisons and having that evidence of direct opinions about older people in the workplace, those things are the best things if you're going to try to bring that sort of claim.
And even if you bring the claim, I mean, it's not like it happens overnight. It costs money. It takes maybe years,
right? It does, but just as employees, remember, you don't need a lawyer to go file a claim with the EEOC. That's the Equal Employment Opportunity Commission. And their website is great. So if you have any thoughts that you're feeling these sorts of things, get on their website, check it out. And they've got details on some generalized language about what the law is and what might support a claim. So that's the great starting point for anyone who's feeling these concerns.
Well, that's good. And because I get that a lot with our clients, that they feel like that could be a reason. And while it could be, age alone isn't necessarily, it's how you act. It's everything from how you talk about your experiences. It's your energy. It's so many different things that hiring is a very subjective process. And it's not just age alone. Granted, some employer may be stupid and just come out and go, hey, we need a younger guy. But I mean, that's not going to happen typically. So yeah, Natalie, thank you. That was a question I had a few people tell me, make sure you ask that before you go. So we did. And I got that.
That's something to do with the fact that your birthday was last week?
Yeah, I was 60. So go figure.
Yeah.
I have no beef about age. I love what I do. And one of the nice things, and Teddy, one of the nice things about the kind of work we do is the older we get, the greater perception is that we've been around and we've seen it all. And it's almost like in some ways a doctor, where if you're just fresh out of school, you think, has this guy ever really seen a whole lot? We've lived it. We've lived it from a job hunter standpoint and an employer standpoint.
I got the scars, but I can't take my shirt off.
Please don't. But but again, we love what we do. We're here to help both Teddy and me. If you're a job hunter, find us on LinkedIn, reach out to us. We've got clients and folks that we're assisting all over the country. And we also get a chance to hang out and have some fun with folks like Natalie to learn more and whether it impacts us today or maybe a month or two or a year from now. Information is good to have. And so Natalie, again, thank you. Thank you so much.
Thank you, Roger. And if anybody has an idea of a topic that you really think would be interesting for this group, then please feel free to share any topic you have with Randy or I. If you can't find us on the internet, we've made a huge mistake because we're really all over it. So
yeah.
Boom. Natalie, thank you very much. Randy, good seeing you today. We'll see everybody in a week.
Take care. Thank you now.